Welcome to the Daily Current Affairs by CivicCentreIAS, where we'll discuss the important articles from the Hindu, the Indian Express and the PIB for the day 26 March 2025. So the first article here says that the Supreme Court on Tuesday asked if the constitutional courts can direct speakers who act as the quasi-judicial tribunals under the anti-defection law to decide the disqualification petitions filed with them under the 10th schedule of the Constitution within a specified time period. In this context, we'll look at the key provisions of the schedule. See, firstly, a member of the legislature is disqualified if they voluntarily give up the membership of their political party, or they vote or abstain from voting contrary to the party's directive without prior permission. But there are few exceptions with respect to it. So, a member is not disqualified if their political party merges with another and the member claims allegiance to the new party, provided 2/3 of the legislature party agrees to the merger. Furthermore, the nominated members of the House can be disqualified if they join a political party after 6 months from taking their seat. Moreover, the speakers and the deputy speakers are not disqualified if they give up their political party membership due to their election to office, as long as they don't rejoin the party during their tenure. Also, the Speaker or Chairman of the House has the complete authority to decide on the disqualification matters and their decision is final. Also, the law prohibits courts from intervening in disqualification matters as per Article 122 and 212 of the Constitution, which protect the internal functioning of the legislative bodies. Lastly, the chairman or the speaker may create rules for implementing the provisions of the 10th schedule, including maintaining records of the party affiliations and the procedures for the disqualification cases. The second article says that Supreme Court on Tuesday took the suo motu cognizance of the Allahabad High Court order of March 17th, which concluded that grabbing the breasts of minor victim and breaking the string of her pajama, bring down her lower garment were not sufficient facts to draw an inference that the accused persons were determined to commit rape. In this context, we'll talk about the suo motu cognizance power of the Supreme Court. See, suo motu is a Latin term which means on its own motion. So, it refers to the power of a court, especially the Supreme Court of India, to take cognizance of an issue or matter on its own initiative without any petition being filed before it or any person approaching the court. So, it acts in the situations where public interest is at stake or when the judicial intervention is necessary to uphold the justice. So, this power enables the court to act in situations where the public interest is at stake or when the judicial intervention is necessary to uphold the justice. Now, what is the legal foundation to it? See, firstly, the Contempt of Court Act of 1971 grants the power to initiate action in cases of contempt. However, the suo motu cognizance is as used in the judicial or writ jurisdiction has evolved, particularly in the context of public interest litigations. Then, the Sunil Batra case of 1978 is often cited as the first instance where the Supreme Court took suo motu cognizance to address the issue of prison conditions in India. So, this marked the beginning of the practice of the suo motu action in PILs. Then, the Supreme Court rules of 2013 formalized the procedure for the suo motu petitions under the Order 38 of Rule 12 Clause 1 Subclause A in 2014, providing more structure to this process. Now, what are the instances where Supreme Court can take suo motu cognizance? See, firstly, the Supreme Court may take suo motu cognizance action if an official or individual or any entity obstructs the administration of justice or disrespects the court's authority. This includes situations where actions may undermine the court's dignity, interfere with its processes, or obstruct justice. Secondly, the court has the authority to order investigation into any case that may involve mistreatment, abuse, or violations of law that may not be raised before the court. So, the suo motu action can also be taken based on media reports, documentaries, or letters from aggregated groups. Then, lastly, if there is new or substantial evidence or information that comes into light after a case has been closed, the court can reopen the case and initiate the proceedings. Furthermore, the court can also act on petitions or complaints about miscarriages of justice that require a review of past rulings. Moving on to talk about the fourth article, It says that now we can use a BHIM, which is the BART interface for money, for tracking, managing, and even splitting expenses with your friends, relatives, and colleagues. NPCI BHIM Services Limited, which is fully owned by NPCI, which is National Payments Corporation of India, launched BHIM 3.0. While BHIM 3.0 will be rolled out across multiple platforms in phased manner, it is expected to be fully available as early as next month. In this context, I will talk about the salient features of the BHIM 3.0 uses. Firstly, BHIM 3.0 will be available in over 15 Indian languages, making it more accessible to a larger segment of population across different regions of India. Then, the app is designed to ensure smooth transactions, even in areas with slow or unstable internet connections, enhancing user experiences in the regions with connectivity challenges. Then, Spend Analytics feature will allow users to track and manage their monthly expenses through their dashboard. So, this app automatically categorizes and classifies the expenses, helping users to understand their spending habits without needing to complex complex spreadsheets, making it easier to manage the personal finances. Then, the task assistant, like the users can now onboard family members and track shared expenses. The app allows users to assign specific payments to each family member, providing a consolidated view of total expenses for better financial planning. Then the task assistant built into the app will remind users about the pending bills linked to their BHIM account, helping them stay on top of payments. So there is also UPI Lite support, where it includes UPI Lite for low value transactions, allowing users to conduct transactions with lower charges and quicker processing. So the users will be alerted with the UPI Lite wallet balance is low, ensuring that they can manage their transactions efficiently. And also there is BHIM Vega for merchants, where is a new in-app payment solution for merchants. It allows the merchants to integrate with online platforms and receive payments seamlessly within the app without having to switch to third-party apps, streamlining the payment process. Now, the next article here says that India and Singapore on Tuesday signed a letter of intent on the green and digital shipping corridor collaboration at the ongoing Singapore Maritime Week. India and Netherlands also discussed the possibility of utilizing Dutch global expertise to enable cargo movement in low draft rivers of Brahmaputra and Barak. In this context, we'll talk about the key features of the agreement. The letter of intent focuses on the joint development of projects aimed at digitalization and decarbonization of maritime sector. So both countries will work towards formalizing the partnership through a MOU for Singapore-India GDSE. Then one of the core goals of the GDSE is to enhance collaboration to accelerate the development and adoption of zero or near zero gas emission technologies in the maritime sector. So the GDSE will serve as a platform to drive innovation and facilitate the widespread use of low emission technologies in maritime operations. Lastly, the initiative aims to strengthen digital integration in the maritime industry, making the sector more efficient and environmentally sustainable. Now, the next article says that in a move which is likely to benefit American big technology companies and also assuage US concerns about the India being a high tariff nation, the central government has proposed to abolish the Equalisation Levy on the key online advertisements, which is a part of the amendments to the Finance Bill of 2025. In this context, we'll see what Equalisation Levy is. An Equalisation Levy is a tax levy to address the imbalance between the domestic and foreign e-commerce business companies. So it ensures that both resident and non-resident digital businesses face similar tax burdens, aiming to equalize the tax treatment. So the 6% equalization levy was introduced in 2016 and applies to the payments exceeding 1 lakh per year made to non-resident service providers for online advertisements. So this levy is often referred to as Google tax because it primarily affected the major offshore technology firms such as Google, Meta and Amazon, who provide digital advertising services to Indian businesses. So the recent change is that the Finance Bill of 2025 proposes to remove this 6% equalization levy on digital ads starting from April 1st of 2025. Now, why this change was brought? See, the 6% equalization levy has been in force since 2016, but its continued imposition became a point of contention with the global stakeholders, particularly United States. Then, in 2020, India introduced a 2% equalization levy on e-commerce platforms offering digital services in India, which also faced criticism from the US for being discriminatory. As a result, India repealed this 2% levy in 2020. Then, in October 2021, India, the US, and other countries under the OECD or G20 inclusive framework agreed to create a global tax framework for the digital economy, focusing on a two-pillar approach to resolve complexities of digital taxation and ensure a fairer and cohesive system. So the last article here says that the medium and long-term long-term government deposits of gold monetization scheme discontinued with effect from 26 March of 2025 based on the performance of GMS and evolving market conditions. In this context, we'll talk about the gold monetization scheme. See, the scheme was launched by the Indian government on 15 September of 2015 with the aim of reducing the country's reliance on gold imports and mobilizing gold by the households and institutions for productive use. So, this scheme encourages individuals and entities to deposit their idle gold with banks, offering them a way to earn interest while contributing to the country's economic growth. Looking at its key features, see there are three types: short term, medium term, and long term. But now the government has abolished these both. Hence, we have only short-term bank deposits, which is 1 to 3 years. So each type has a specified lock-in period and interest rate, which varies according to the duration and the terms of deposit. So as I said, the medium-term and long-term gold deposits will no longer be available from 26 March of 2025. However, existing deposits under these components will continue until the redemption based on the original terms. So the short-term deposits will continue, but the rates and terms are at discretion of the individual banks. Now, who are eligible for participation? See, resident Indians, including the individuals, HUF partnerships, companies, trusts, mutual funds, and even government entities can make deposits under the scheme. So, as there are not much articles, we have discussed 6 articles in total for today from the Hindu, the Indian Express, and the PIB. We'll be back again with another video tomorrow. Thank you.